Have you ever heard someone say to you, do this one thing to get the state to drop the child support case against you? That sounds like a magic trick, but under Arkansas law, there is no magic phrase or magic form that makes a real child support debt disappear. What does exist is a set of very specific rules that decide 1, when OCSE can close an enforcement case, 2, when a court can modify or terminate support, and 3, when the custodial parent's choices matter and when they do not. The goal today is to walk through what actually works, what absolutely does not, and what a father in Arkansas should do if he wants the state support system off his back. My name is Leon Jones Jr., and for over 15 years, I have practiced in both state and federal courts here in Arkansas. I've also worked for a Fortune 100 company and held the positions of the Director of the Arkansas Department of Labor, as well as the Executive Director of the Arkansas Fair Housing Commission. Now, I'm the Managing Attorney here at Big Rock Legacy Law Group, where we advise and represent our clients in business law, civil litigation, estate planning, and family law. Over these many years, I've had families deal with this very issue, and I hope this video provides some insight into how I provide advice to my clients, which is very different from each and every client. Part 1, how Arkansas child support really works. In Arkansas, most state child support cases are run through the Office of Child Support Enforcement, or OCSE. It's a division of the Department of Finance and Administration. OCSE's job is to establish paternity, set support, and enforce orders, especially in cases tied to public assistance, foster care, or when a parent applies for services. First, let's understand how the system is structured. A judge sets the support order using Administrative Order Number 10 and Income Shares Chart. OCSE does not invent the numbers, and OCSE collects. They have very strong enforcement tools such as wage withholding, tax refund intercepts, license suspensions, liens, and even criminal non-support referrals in extreme cases. Keep in mind, child support automatically terminates by law when certain events occur, usually when a child turns 18 or is out of high school, but arrears do not vanish. This means the state's case is really OCSE enforcing a court order, not them deciding on their own how much a father should pay. To get the state to back off, the strategy has to target either the underlying order or OCSE's justification for keeping an enforcement case open. Part 2, how and when OCSE is allowed to close a case. Arkansas follows federal regulations and has its own case closure rules that list the acceptable reasons for OCSE to shut down an enforcement case. These criteria are found in the Arkansas Code of Rules for OCSE and the OCSE Policy Manual. Some of the most important closure grounds for fathers to understand are, number 1, if there's no longer a current support obligation and arrears are under $500, or there's no realistic way to collect the support. Number 2, all the children are grown, no more support is ongoing, and the non-custodial parent is in a long-term care with no income or assets below substantive levels. And number 3, OCSE can't locate the parent or assets and are required to shut down the case because there's no reasonable prospect of collection. And number 4, in cases where cooperation is not required for public benefits, the custodial parent puts in writing the request to close and there are no arrears assigned to the estate. And number 5, there's a documented good cause finding that the enforcement will risk harm to the child or to the custodial parent. Notice that it is not on the list, dad doesn't like the amount, dad lost his temper with the caseworker, or mom and dad privately agreed to something different without a court order. If the situation does not fit the closure category, OCSE is not supported or supposed to close the enforcement case, even if both parents say that's what they want. Part 3, the one thing that matters most, fix the court order, not the caseworker. If a father wants the state to back off, the most powerful move is not arguing with OCSE, it's getting the court order changed or terminated under Arkansas law. There are 3 main routes. Number 1, termination when the law says support ends. In Arkansas, a payer's duty to pay ongoing support ends by operation of law when a child reaches 18 and is out of high school, or when other triggering events occur, the payer must then give written notice within 10 days to the payee, the clerk, the employer if there is withholding, and OCSC, naming each child whose obligation is ended and enclosing the current order. After that, anyone, either the parent or OCSC, can file a motion to adjust the remaining support amounts. Number 2, modify the order when income or circumstances change. Under Administrative Order Number 10, Arkansas case law allows for modification when material changes in circumstances occur, typically including a significant or continuing change in income. The corrective move is a motion to modify in the proper circuit court with documentation of the current income, expenses, and any changes in custody or parenting time. If the court lowers the support or ends the ongoing obligation, OCSC's enforcement focus shifts to whatever arrears may remain under the new order. And number 3, correct paternity if it was wrongly established and the law allows for relief. Paternity can initially be established by an acknowledgement on a birth certificate or by a court order. A voluntary acknowledgement can be rescinded only within a very short window, generally about 60 days, or before a related court proceeding, after which time the standard is much higher, often requiring a court order of disestablishment based upon fraud, duress, or material mistake. Where paternity is properly disestablished, the support order tied to that child can be vacated, and OCSC may have grounds to close the case. This that actually moves the needle is filing the right motion in the right court and getting a signed order that changes OCSC's marching orders. To learn more about how we assist our clients with these and other types of legal situations, click below and let's get started today. Now, part 4, what the custodial parent can and cannot do. Many fathers are told if the mother just tells the state to drop the case, then OCSC has to close the case. That often is wrong in Arkansas. Here is the real picture. Number 1, if the child or custodian has received certain types of state assistance like TEA cash payments or some type of foster care payments, support rights are assigned to the state by law. In these situations, the custodial parent cannot waive or forgive the state's claim, even if they want to. If there is no required cooperation or benefits or no arrears assigned to the state, then the custodial parent can submit a written custodial party request to close the case form from OCSC. OCSC may close the enforcement case in that scenario, but any private obligations between the parties under a court order may still exist. One legitimate path for a father is to work to repair the relationship enough that the custodial parent is willing to A, sign a written request for case closure with OCSC where it is allowed. The parties can also sign an agreed court order, for example, agreed modifications or agreed termination when a child has aged out or circumstances are such that a change is necessary. But even if the parties are in full agreement, the law still requires the judge's signature to change the support order, and Office of Child Support Enforcement can still have to follow their rules in order to close the case. Part 5. Let's talk about a step-by-step game plan for fathers. A practical roadmap for a father to follow in Arkansas if the goal is to get the state out of its pocket as much as possible and as lawfully as possible is to, number 1, get clarity on the exact status of the case. So call or visit the local Office of Child Support Enforcement or visit the My Case platform to confirm there is an open case, what the current monthly obligations and arrears may total, and if any arrears are assigned to the state because of public benefits. Then request a payment record of all copies of the current order. Number 2, check whether the child support has already ended by operation of law. Verify each child's age and school status and Arkansas guidance on when support obligations terminate. If a child has aged out, send the required written notices within 10 days to the other parent, to the clerk, to the employer if there's withholding, and to the Office of Child Support with a copy of the order listing each child whose obligation has ended. Number 3, if the amount is unaffordable to the father, focus on modification, not ignoring the order. gather proof of current income, which includes pay stubs, tax returns, disability determinations, job loss documentation, file a motion to modify in the circuit court that issued the order, citing the material changes and circumstances, which are consistent with Administrative Order Number 10, and ask for an order that lowers the ongoing support to what the guidelines actually require, and, if appropriate, set a reasonable payment plan on the arrears instead of letting them snowball. Number 4, if appropriate, explore whether the custodial parent can request closure. Ask, is cooperation with OCSC a condition of current public assistance? If so, the custodial parent may not be able to close the case. But if not, there are no assigned arrears, the custodial parent can then complete the form we talked about above and deliver it to OCSC. Even after closure of the enforcement case, a court order can still be enforced privately through contempt in some situations. So fathers should not assume that all the legal financial obligations just vanish if OCSC closes their case. Number 5, stay compliant while fighting for relief. Arkansas does not erase arrears because a parent filed for modification. Support keeps occurring until the order is changed. Partial payments, even small ones, can help avoid the most aggressive enforcement measures and show good faith efforts if the contempt or criminal non-support is raised. Completely stopping payments without a court order is one of the fastest ways to trigger license suspension, tax intercepts, and possible jail time. Now, done correctly, the combination of termination when the law says the duty ends, modification when changes occur, and proper documentation when closure requests are allowed gives a father a realistic chance to either get OCSC out of the picture or at least reduce the intensity of their enforcement. Part 6. Here are some myths that get fathers in trouble. Number 1, when you say, if we get back together, I don't have to pay what's owed. Reconciliation between the parents does not erase arrears unless and until a court addresses the order and any assigned arrears to the state. OCSC still follows the existing orders. Number 2, if the mother writes a letter saying I don't have to pay, the state will drop it. Custodial parents' private forgiveness does not cancel assigned arrears or a valid court order. And OCSC cannot close a case that does not meet the closure criteria. Number 3, I can just work for cash and they can't touch me. Arkansas can use tools like license suspension, reported income, tax intercepts, and even contempt to enforce arrears. Evasion often makes things worse, not better. Number 4, if I just ignore the papers, they can't set support. Default orders can be entered when a parent fails to appear, and those orders are enforceable just like any other orders, often at amounts higher if the parent had participated. The real this in Arkansas is not a trick. It is understanding the law, using the courts to change what can be changed, and working within OCSC's own case closure rules when they actually apply. When fathers follow the path set out above, they give themselves the best lawful chance to get the state to close its child support case or at least step back from the harshest enforcement tools. The stakes underscore the real professional guidance and coordinated planning with an experienced attorney. I encourage each of you to evaluate your situation early and discuss your unique needs with a qualified professional to secure the best outcomes. Make sure to subscribe to this channel to learn more about how we here at Big Rock Legacy Law Group provide valuable information to protect our clients' legacy and advocate for our clients' rights.